Greetings students, I hope that you're all doing fine. This being the very first lecture of this certification course on law of contracts, I would start from section 2 itself. And as I had previously mentioned in the introductory video, besides explaining the different provisions via judgments of both Indian and foreign courts, I would also be discussing with you the previous year previous PCSJ examination questions, both prelims and mains, so that it becomes easier for you to get the entire structure of the examination, to learn how exactly questions are asked and what area should we emphasize as we understand the given sections. And in order to do that, I would be attaching a PPT as I speak, so that everything that I'm going to discuss with you here today, it would appear on your screen and you'd be able to read the concepts as I talk about them. So let's begin.
Now, section 2, that is the interpretation clause, is read as: in this act, the following words and expressions are used in the following senses unless a contrary intention appears from the context. So students, as we can see on the screen, this question was asked in UPPCSC examination of 2012, whereby the question read that the interpretation clause of the Indian Contract Act of 1872 has been provided in which section. So I would not even discuss this question with you, because as you can see on the screen, it is pretty much evident that this part is taken from section 2. So let's start with section 2 itself. Subsection A says that when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. Now, this is the very definition of proposal which you must remember to write every time a question on proposal or invitation to proposal is asked in the exam. This is the precise definition which you should rather memorize. And a question has been asked already on this part, and it was asked in 2003, UPPCSJ 2003. The question said, which of the following is a valid acceptance of a proposal? So as we can see on the screen here, C is the correct answer, whereby when an acceptance is made in a manner prescribed by the proposer, that is when there is a valid acceptance of a proposal. It doesn't matter if it is made in usual and reasonable manner but not in a manner prescribed by the proposer. What's important is that it must be made in a manner prescribed by the proposer. So moving on, subsection B says that when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. So this is a two-way stage process if you think about it, because first it starts from a proposal, and once the proposal is said to be accepted, that is when it becomes a promise. So again, it was a very easy question, anybody could solve it. Whatever is being talked about in the definition, verbatim the question was asked. A proposal when accepted becomes a promise. Moving on, in subsection 3, in subsection 2C, the provision says that the person making the proposal is called the promiser, and the person accepting the proposal is called the promisee. That is fair enough. Subsection D says that when at the desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or to abstain from doing something, such act or abstinence or promise is called a consideration for the promise. So subsection 2D of Indian Contract 1872 is as important as section 25, and that both talk about the consideration. Consideration is a very important topic to be talked about, which will also be dealt later. However, in this part, we would be confining ourselves to the very definition of consideration. So many questions, as you can already see on the screen, have been asked on this topic. In 2012, UPPCSJ, the question said, which one of the following is not essential for a contract? Then in UPPCSJ 2012, again this question was asked, which of the following statement regarding consideration is not correct? Now I'm reading these two questions straight out because I want to mention something in front of your eyes, and what that thing is that consideration does not need to be adequate. Yes, there must be consideration. It is an essential for a valid contract. It must be a lawful consideration. That too is very important, but it does not need to be either an adequate consideration or a valuable consideration. When we use words like adequate consideration or valuable consideration, what we naturally do is give that consideration a rather qualified substance. So the consideration becomes qualified the moment we say adequate. But in order to form one of the essentials of a valid contract, all we need is consideration. So in UPPCJ 2015, this question was asked, as you can see, consider following statements and point out which of them is correct. An agreement made without consideration is void. That is correct. Consideration should be valid in the eyes of law. That too is correct. Consideration has to be adequate. Now again, as I already mentioned, it does not need to be adequate. So B was the correct answer. And then in UP PCSJ 2015, a question was asked, an agreement entered into free consent and lawful but with inadequate consideration is. So you can see where we're going with this. Consideration needs to be lawful. At the same time, it does not need to be adequate. It needs to be lawful consideration. Moving on, in subsection 2E, the act says every promise and every set of promises forming the consideration for each other is an agreement. Now, this is for the first time in the act. This is where agreements definition is being talked about. It's very important that we demarcate the two ideas, that is agreement and a contract. And here is the place where it all begins. So please focus into this. Subsection 2F says that promises which form the consideration or part of the consideration for each other are reciprocal promises. Subsection 2G says an agreement not enforceable by law is said to be void. And subsection 2H says that an agreement enforceable by law is a contract. So you can see the demarcation that has been made. Now, in the coming part of this lecture, we will also be discussing, we will be emphasizing on this difference by way of a previous year question. For now, we would move on to section 2, subsection 2I, that is an agreement which is enforceable by law at the option of one or of the parties thereto, but not at the option of the other or others, is avoidable contract. So the idea of avoidable contract comes into picture when we talk about the matter of free consent, whereby we would be discussing various forms which takes away free consent from a person, such as undue influence, coercion, misrepresentation, fraud, mistake. Subsection 2J says a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. So in 1991, the question 9A of 1991 said that all contracts are agreements, but all agreements are not contracts. What conditions have been laid down in the Indian Contract Act for an agreement to become a contract? So, as I was talking about the idea of agreements earlier, we all know that all agreements are certainly not contracts, then actually all contracts are agreements. The reason behind that is that an agreement goes through a certain process to become a contract. So a contract is nothing but a conclusion, a culmination of an agreement. And if an agreement takes some other direction, if it goes the wrong way, or if it uses certain element which do not form the valid essentials, then it does not become a contract. Then it does not go in that direction to necessarily be concluded with a contract. And what is that direction? That direction is nothing but enforceability. That agreement must be enforceable by law. So as a model answer, I would suggest you that if you had this question if this question was asked to you, you should have started with explaining with section 2H, then you should have talked about section 2E, then you should have talked about section 2G, then section 2I, and then you should have mentioned the idea about illegal agreements. And finally, you should have concluded with what the question says, that is all contracts are not agreements, but all agreements are contracts. And you should have done this by mentioning the idea of enforceability. So actually that is it. All contracts are agreements, but all agreements are not contracts. So you must keep this idea in your mind. Now, moving on, in question 2, that is in question 2 of 1997, the question said that all contracts are agreements, but all agreements are not contracts. Now, again, as you can see, this question has been asked. This is a very important concept. It is a pretty simple concept. In a way, you can understand that these are the questions which actually give you a brownie point, as you are already very well prepared, and the same question is asked on the similar lines every now and then. So I hope that if this question is asked again, you will be promising. Now, question 2G in 1997 was asked, and the question said, proposal and invitation to proposal. We had to write short notes on any of the following, in which this was one of the topics. So for proposal, I would say that we need to start from, we need to quote the section, the definition which has been mentioned in section 2A, because that is the most definitive idea in on this topic. And then we must differentiate by mentioning what is an invitation to proposal. We can do this by giving an illustration or a case law. Illustrations are more handy because you do not need to burden yourself with the name of a case law. So if I were to give a good example of an invitation to proposal, differentiating it from proposal, then I would say auctions. For example, when an auction is announced, it is an invitation to proposal. Even when there is a bid that is going on in the auction, and there are people who bid who bid with their offers, uh, these are merely invitation to proposal. And these invitations, they need to be accepted by the person who is administering the auction, the person who is conducting the given, who is controlling the given auction. Just like that, another good example would be a shop, whereby you enter into a shop, you see a lot of goods sitting just by the shelves, and you pick one of those goods up and you go to the shopkeeper, you pay them the money, and you tell them that as naturally you saw these goods, and the shopkeeper is making an offer, so you're taking these goods. But then the shopkeeper would quote to you the Indian Contract Act, whereby he would tell you that the goods lying in the shop are actually an invitation to proposal and not the very proposal itself. So I hope that this clears up the very section 2 of Indian Contract Act 1872 in your mind. Still, if you have any doubts regarding any of the provision, you can always hit me up with your queries. Now moving on, we would be talking about communication of proposal. So section 3 of Indian Contract Act of 1872 says communication, acceptance and revocation of proposals. So the communication of proposals, the acceptance of proposals, and the revocation of proposals and acceptances respectively are deemed to be made by an act or omission of the party proposing, accepting or revoking, by which he intends to communicate such proposal, acceptance or revocation, or which has the effect of communicating it. So this section is pretty easy to understand, whereby, as we had mentioned in section 2A, the idea of proposal, now we're talking about communication of such proposal, because proposal is only the beginning, and it is only through the communication of such proposal that acceptance can be reached at, and the same process is taken for revocation of the given proposal. So we would be discussing certain case laws. For example, it was held in P. Poppen versus Karya Gondar that an offer and acceptance need not always be formal, nor does the law of contracts or of sale of goods require that consent to a contract must be in writing. So it talks about way of a communication, and the consent does not need to be in writing. It was held in this case. In another case, that of Coffee Board versus CCT, it was held that an offer and an acceptance can be spelled out from the conduct of the parties, which covers not only their acts but also omissions. So here it talks about a situation whereby any conduct of a party not only leads to acceptance of a proposal, but also any such omission by any such conduct which leads to an omission by any of the parties can very well explain itself in the way that the communication is given for the acceptance. So that is there, and it is very important to quote these cases in the exam, because we need to have a certain authority. Obviously we need to explain what the provision says first, especially when the provisions are complex, as you would see in the coming lectures. But it's equally important to also mention the case laws, as they provide you a very decent authority. And once you have written down the landmark judgments on different issues, there is no examiner who has the right to not give you the marks for an answer. So it was held in this case that an offer which is expressed by conduct is called an implied offer, and the one which is expressed by words, written or spoken, is called an express offer. It is rather an understandable provision. There is nothing new here. And in another case with that of Maharashtra Rajya Sahakari versus Manga Bhaga Chaudhary, it was held that a contract implied, in fact, requires a meeting of minds. The courts have to refuse to read an implied term into a contract which is silent on the point or did not clearly indicate the nature of terms. So we can see here that conduct is pretty much understandable, but when we use that conduct for using for communicating our acceptance, then it must also be clear, it must also be lucid enough to be understood. As conduct and as a contract which is implied in fact, it requires meeting of minds, and the courts, they need to have a certain clarity on the matter of a conduct of acceptance to clearly hold that the acceptance was made in such a case. So a question was asked in UPPCSG of 2012, whereby the question read that A proposes by letter to sell a house to B at a certain price. The communication of proposal is complete when, and it is complete when B receives the letter. So that is it. When the person who proposes, he communicates such proposal to the person who for whom the proposal is actually intended. That is the time when the proposal is actually complete. That is, the communication of proposal is actually complete. So this was the answer. And in UPPCSJ 2013, a question was asked: for an acceptance, mere mental resolve to accept would not be sufficient. There must be some external manifestation of the intent by speech, written, or other act. Now, this is a pretty understood principle. It is decently understood, but the question which was asked there was, which judgments was this part held in? And it was held by the Supreme Court in Bhagwan Das versus Girdhari Lal and Company. So, as students, as we can notice here, it is not only the provisions, the established facts which are important to be memorized. It is also the judgments, especially the landmark ones. So, I would suggest you to take down notes of these questions and memorize them, because and also research on what these different judgments talk about, because doing so will only help you. As many a time what happens is that a similar question is asked which gives similar options, and even though you know one or two options, you need to know the other two options too, as they may be asked in another question in another examination, in the later examination. So knowing the other options will help you to come up with the elimination strategy, especially in prelims, only in prelims. So in context of mains, a question was asked on this topic in 2013. The question was 10B. It said, it was a practical question. It said that A teaches his parrot to recite an offer and then sends the parrot to B. The parrot repeats the recitation. Is this a valid offer? Will it make any difference to your answer if A ties a message containing an offer for B on the body of the parrot who carries the message to B? Now, students, we must understand over here what the law is being asked here, which law is being asked here, because it's a practical question, but at the same time, it is based on one of the illustrations in the Bail Act. So, in this question, what we had to do was actually mention Section 2H, talk about the essentials of a valid proposal, and then conclude that since a parrot is neither a legal person nor a natural person, a parrot cannot make any proposal or offer. That would have done it. So now I would be talking to you about section 4, which says communication when complete. So the communication of a proposal is complete when it comes to the knowledge of the person to whom it is made. In UPPCSJ 2006, a question was asked whereby it said, which one of the following is not provided in section 4 of the Indian Contract Act of 1872? A. Communication of a proposal. B. Communication of acceptance. C. Communication of revocation. And D. Revocation of proposals and acceptance. So as we all know, revocation of proposal and acceptance comes in the later section and it is not dealt in section 4. So while we're talking about section 4, it becomes very much important to mention the case law of Lalman Shukla versus Gauri Dutt, whereby the defendant's nephew absconded from home and the defendant sent his servant in search of a boy. When the servant had left, the defendant by hand bills offered to pay rupees 501 to anybody discovering the boy. The servant came to know of this offer only when he had already traced the missing child. He, however, brought an action to recover the reward, but his action failed. Explaining this principle, Justice Banerjee said that in order to constitute a contract, there must be an acceptance of an offer, and there can be no acceptance unless there is knowledge of the offer. So this is one of the very important takes of this case law, and you must take note of the same. Again, in UP PCJ 2015, a question was asked which says in the following cases, which case relates to general offers? So in this question, it was seen that both Lalman Shukla versus Gauri Dutt and Cargill versus Carbolic Smoke Ball Company deal with general offers. So moving on, we would be talking about the intention to create a legal relationship. Now, this provision, it has nowhere been mentioned in the Indian Contract Act, requiring that an offer or its acceptance should be made with the intention of creating a legal relationship. However, it has been illustrated in Balfour versus Balfour based on the English law. And now it's a settled principle that to create a contract, there must be a common intention of the parties to enter into legal obligations. So, as you can see on the screen here, the facts of this case, whereby the defendant and his wife were enjoying leave in England, where the defendant was due to return to Ceylon, where he was employed, and his wife was advised by reason of her health to remain in England. The defendant agreed to send her an amount of £30 a month for the probable expenses of maintenance. He did send the amount for some time, but afterward, differences arose, which resulted in the separation, and the allowance fell into arrears. Now, the wife's action to recover the arrears was dismissed, and Lord Atkin explained the principle whereby such arrangements, where there is an offer and acceptance of hospitality, do not result in contracts at all, even though there may be what would constitute consideration for the agreement. So they are not contracts because the parties, they do not intend that they shall be attended by legal consequences, and it is pretty much understandable. So we notice here that the test of contractual intention is rather objective and not subjective. What matters is not what the parties have in mind, but what a reasonable man would think in the circumstance their intention to be. So, in the case of CWT versus Abdul Hussain Mullah Muhammad Ali, for instance, whereby one partner had lent a large sum of money to the other to be utilized as capital in the partnership venture, and the transaction was in the context of a commercial nature, it was the presumption that legal obligations were intended. So we can see that like there's a certain kind of a variability in such kind of, why the whole matter depends upon whether the conduct of the parties in the surrounding circumstances affords evidence of objective intention. For example, there are contrasting judgments on the similar viewpoint, whereby in merit versus merit, an agreement to transfer to the wife the beneficial ownership of the matrimonial home made at the time of separation was held to be binding. But at the same time, in gold versus gold, an agreement similarly made was held to be not binding, as the husband undertook to pay only as long as he had the means to pay. So, uncertainty of these words showed that no legal relations were contemplated. At the same time, the Supreme Court, in the Indian context of this given provision, has expressed its reservation about the need of this separate requirement of intention to contract under the Indian Contract Act. And in CWT versus Abdul Muhammad Ali, the Apex Court has noted that the general provision that in addition to the existence of an agreement and the presence of consideration, there is also the third contractual element in the form of intention to create legal relations, and also noted that this proposition, though accepted in English law, has not passed unchallenged. So it is still an open question whether the requirement of intention to contract is applicable under the Indian Contract Act in the way in which it has been developed in England. So we must understand here that it is one of the essentials of a valid contract in Indian Contract Act 2. Here, in this given judgment, although the court has mentioned that there is reservation whether it is applied in the Indian Contract Act in the same way in which it has been developed in England, that does not mean that this provision, this proposition does not apply in Indian Contract Act. So be clear with that. And that is why PCSJ examination in UP PCSJ 2013, this question was also asked, that difference between a contract and a social agreement is that of, and the answer for this question, as you can see right in front of your eyes, is intention to create a legal relationship. So now that we're done with the intention to create a legal relationship, I would be talking about the idea of general offers with you. It was suggested in the old case of Weeks versus Tybalt that an offer must be made to a definite person. That case arose out of a defendant's affirmation to the public that he would give £100 to him, that should, if he agrees to marry his daughter with his consent. So the plaintiff here alleged that he did so and sued the defendant. But the defendant rejecting the action, uh, and when the defendant rejected the action, the court said that it is not averred nor declared to whom the words were spoken. So over here, it was held that the difficulty suggested was that if an offer of this kind addressed to several persons could be accepted, the offerer would find himself bound in innumerable contracts. Now, this was, however, soon overruled, as it is pretty logical. Even we must understand it that the modern position is that an offer may be made to the world at large, but the contract is not made with all of the world. Contract is made only with that person who comes forward and performs the conditions of the proposal. So as you can see on the screen here in UP PCSJ 2006 examination, different case laws were mentioned again, and what was matched with these case laws were the ideas that were held in these case laws to become various established facts to be applied in Indian Contract Act. And we can see over here that in the case of McGregor versus McGregor, it was held that McGregor was it was held that intention to contract is an essential. At the same time, in the case of Geeks versus Tybalt, it was held that general proposal is basically a law on general proposal was established. And Henderson versus Stevenson, it was actually the reasonable notice which was mentioned, and it in Curie versus Misa, it was the consideration aspect which was talked about. Now, it is important when we match these conditions which were laid down in these cases, we must also realize that what were the other ideas that were dealt in these cases. Because now that we are done with this given question, we are aware of these given provisions, these given ideas which were held in these cases. But there must be many other aspects which were dealt in these cases. So if a question is asked in the subsequent examination and it uses the similar case law, but asks for a different idea that was established in these case laws, then we would be at a better position to answer such a question. So while we're talking about the idea of general offers, in the landmark case of Cargill versus Carbolic Smokeball Company, a company offered by advertisement to pay £100 to anyone who contracts the increasing epidemic influenza, colds, or any disease caused by taking cold, and after having used the ball according to the printed directions. Later, it was also added that £1,000 is deposited with the Alliance Bank, showing our sincerity in the matter. That is what the provision said. And then the plaintiffs used the smoke balls according to the directions, but she nevertheless subsequently suffered from influenza. She was held entitled to recover the promised reward. In such cases, students, proposals, they are acceptable by conduct, and communication of acceptance is not necessary. So this is the reason why the court held that she was entitled to recover the promised reward. In addition to this, the fact that £100 deposit was made with the Alliance Bank, it also showed their sincerity in the matter. That is, they were having the intention to form a contract. So question was asked in UPPCSJ 2012, whereby the question said, in case of a general offer, there is a need to communicate the acceptance if not required by the proposer. This has been held in, again, different case laws were mentioned. So as you can see, Cargill versus Carbolic Smokeball is the answer here, but I would advise you to read about different other case laws that I have mentioned on the screen here. Since we're talking about the acceptance of the proposal and its communication by conduct, I will be talking about section 8, which says that acceptance by performing conditions or receiving consideration. Performance of the conditions of a proposal or the acceptance of any consideration for a reciprocal promise which may be offered with the proposal is an acceptance of the proposal. Since the topics are closely related, I will be discussing it over here only. So the principle of this section was implied in the case of Harbhajan Lal versus Harcharan Lal. And the facts of this case was is that a young boy ran away from his father's home, and the father eventually issued a pamphlet offering a reward in these terms. The pamphlet said that anybody who finds traces of the boy and brings him home will get rupees 500. The plaintiff here was at the railway station. There he saw a boy. He overheard part of the conversation and realized that the boy was the missing boy, and promptly took him to the railway police station. And the plaintiff sent a telegram to the boy's father that he had found his son. So over here it was held that the handbill was an offer open to the whole world and capable of acceptance by any person who fulfilled the condition, and that the plaintiff substantially performed the condition as well and was entitled to the amount offered. So where a general offer is of a continuing nature, as it was in the smoke ball case, it will be open for acceptance to any number of persons until it is retracted. But where an offer requires some information as to a missing thing, it is closed as soon as the first information comes in. Now, lastly, we will be talking about the offer and invitation to trade. So, an offer is nothing but the final expression of willingness by the offerer to be bound by his offer, should the other party chooses to accept it. This may be inferred from the definition of proposal in section 2a, which emphasizes that there should be the expression of willingness to do or to abstain with the view to obtaining the assent of the other. So the offerer must have expressed his willingness to contract in terms of his offer with such finality that the only thing to be waited for is the assent of the other party. So, where a party, without expressing his final willingness, proposes certain terms on which he is willing to negotiate, he does not make an offer, but only invite the other party to make an offer on those terms. This is the basic distinction between an offer and an invitation to receive offers. And I had also discussed with you in earlier in this lecture two examples of this distinction. So in the Privy Council in Harvey versus Facey, which again is a landmark case on this topic, has explained this distinction. So the facts of this case were that the plaintiff telegraphed to the defendants, writing, "Will you sell us bumper hall pen?" The and telegraphed lowest cash price. Here the defendant replied also by telegram that lowest price for bumper hall pen is £900. Here the plaintiff immediately sent their last telegraph stating, "We agreed to buy bumper hall pen for £900 as by you." So all of you must be wondering here, what has actually happened? Is there a contract or no contract? Well, there is actually no contract. Why? You'll see. Because the defendants, however, refused to sell the pen at that price. The plaintiffs contended that by quoting the minimum price in response to the inquiry, the defendants had also made an offer to sell at that price. However, their lordships pointed out that in the first telegram, the plaintiffs had asked two questions. First, as to the willingness to sell, and second, as to the lowest price. But the defendants answered only the second and gave only the lowest price. So they have reserved their answer as to the willingness to sell, and thus they had made no offer. The last telegram of the plaintiff was an offer to buy, but that was never accepted by the defendants. So that is it. And in relation to this topic, there are two subtopics, that is catalogs and display of goods. Number one, whereby we must understand that a shopkeeper's catalog of prices is not an offer. It is only an invitation to the intending customers to offer to buy at the indicated price. Thus, it has also been held in Pharmaceutical Society of Great Britain versus Booth Cash Chemist Southern Limited that the display of goods in a shop with price sheets attached is not an offer, even if there is a self-service system in the shop. And another subtopic related to this topic is that of announcement to hold auctions. So on this note, as I was already giving you an example earlier, It has also been held in Harris versus Nickerson, whereby an auctioneer's announcement that specified goods will be sold by auction on a certain day is not an offer to hold the auction, and he will not be liable to person he will not be liable to the person traveling up to the place if he changes his mind and does not hold the auction. At the same time, it has also been held in Spencer versus Harding that even when an auction is held, the bid is not an acceptance so as to entitle the highest bidder to get the goods. The highest bid is nothing more than an offer to buy, and it requires to be accepted by the auctioneer. So on that note, a similar question was asked in the PCSJ UP PCSJ examination of 2013, whereby we had to match list one with list two, and in the list one, a railway timetable was a general offer, a public notification for tender was an invitation to offer, and a picking an article from shelves and putting it in his basket in a self-serving mall was not the acceptance of the offer. And in a situation where A says to B that if A's offer is not accepted, B should say no immediately, yet B keeps silent. This situation was actually an acceptance of an offer.
So that sums up the first lecture of this certification course on law of contracts, as a part of which I have discussed with you section 2, section 3, section 4 and section 8. And while talking about section 4, there were many areas, many categories of cases which have led to evolution of section 4, which I would be continuing on in the next lecture as well. And in the next lecture I would be finishing the chapter 1 of Indian Contract Act of 1872. So I hope that whatever we discussed today, you would be able to solve questions coming from the same topics. And I would be attaching the PPT of this lecture so that it becomes easier for you to revise the given concepts. Thank you. Till we see each other again.